What is the statute of limitations on debt in NJ?
Even though consumer debt can seem like a private matter, there are specific laws and regulations that govern when and how they can be enforced or disposed of. An example of such laws includes the Statute of Limitations on Debt in New Jersey. New Jersey laws regarding consumer debt can prove to be very complicated to understand without the help of an experienced New Jersey debt negotiation attorney. At Straffi Straffi Attorneys at Law, our team of skilled legal professionals has protected the rights of New Jersey residents from unlawful debt collection practices.
We offer quality legal counsel and representation to advocate for our clients' best interests. To learn more about how we can help, contact us today at 732-341-3800. New Jersey Statute of Limitations on Debt.
There are different statutes of limitations in New Jersey depending on the type of debt you have. For most debts including credit card debt, the limitation is 6 years.
For car loans, the limitation is 4 years.
The statute of limitations is the time in which the creditor can file a lawsuit against the debtor to compel them to pay their debt. This period initiates at the last interaction the debtor had with the creditor and will reset each time they make contact again. This contact refers to the last time the debtor made a payment on their debt. The statute applies to all types of contracts in New Jersey, be it oral or written contracts, open-ended accounts, or promissory notes.
Judgment on debts in New Jersey.
Creditors can file a case to obtain a judgment to collect on a debt as long as the statute of limitations has not expired. It is crucial that you respond to the lawsuit as not acknowledging it can provide the creditor with a default judgment giving them the legal backing to proceed with the collection. There are a few ways that creditors can use to collect on a debt, and the type of collection they use can depend on the circumstances of the case.
Wage garnishment.
Under wage garnishment, the judgment creditor can take a percentage of the judgment debtor's wages as repayment until the court-awarded amount the judgment was issued on is paid in full.
According to federal law, a judgment creditor can collect the lesser amount between 25% of the judgment debtor's disposable earnings. Disposable earnings less than 30 times the federal minimum wage. Disposable earnings in this context refers to wages you earn after the deductions required by law. Also specific to New Jersey law, $48 is exempt from being seized in wage executions, and the judgment creditor can only garnish wages not exceeding 10% of the judgment debtor's income if they earn less than 250% of the federal poverty level for their household size. When this method is used, the judgment debtor's employer will be required to withhold the wages and pay them to the assigned special civil part officer on the case. Any military benefits and wages cannot be claimed in a judgment for wage garnishment. Bank liens. With a bank lien, a judgment creditor can freeze the judgment debtor's bank accounts to be able to get payment on the judgment amount through a motion to turn over funds. Liens. As with bank accounts, the judgment creditor can also apply a lien on the judgment debtor's real estate properties or personal properties. Writs of execution. With the help of law enforcement such as the sheriff's office, creditors can obtain the judgment debtor's personal assets and property, not including real property, as payment for the judgment award. It is unwise to try and hide any funds you have in an attempt to avoid payment, as it can be considered fraudulent behavior and carry additional legal consequences. Once a judgment on the debt is issued, a judgment debtor can be left with few options other than paying the award without the help of a skilled attorney. The statute of limitations on a debt judgment in New Jersey is 20 years. Debt collection statute of limitations. The debt collection statute of limitation refers to the timeframe within which a creditor can legally compel a debtor to pay off their debt through filing a lawsuit. This period starts with the debtor's last interaction with the creditor, which typically involves a debt payment. Each new interaction resets the clock. Under the Fair Debt Collection Practices Act, creditors are required to inform the debtor of the debt's expiration date. However, they may not provide this information voluntarily or accurately. Therefore, it's crucial to maintain your own records and request verification of the last payment or activity on the debt within 30 days of receiving a debt notice. Despite the statute of limitations, the responsibility to manage and verify debt records primarily rests with the debtor. What happens to your debt after 10 years of not paying it? The statute of limitations is a legal time limit set by law that dictates how long a creditor or debt collector has to initiate legal proceedings against you to recover the debt. Once this period passes,
they can no longer initiate a lawsuit to enforce the debt. However, this does not mean your debt is erased or that you no longer owe the money.
Legally, the debt still exists.
Debt collectors might still try to contact you to recover the unpaid debt using traditional collection methods like phone calls or letters. However, if the statute of limitations has expired, they cannot legally sue you over the debt. It's important to note that any acknowledgement or payment towards the debt can potentially reset this clock, making it possible for creditors to sue for recovery once again.
Understanding your rights and the relevant laws is crucial.
If you are approached about a debt that's over 10 years old, consult with a legal professional to discuss your options and ensure that your actions do not unintentionally renew the debt's legal enforceability. Consulting an experienced New Jersey debt negotiation attorney is crucial to avoid any potential issues. Our team of legal professionals at Straffi Straffi Attorneys at Law can help you understand your rights under the law and fight for your best interests. We understand the toll financial vulnerability can have on a person and work hard to help our clients have a chance at a new start. Contact us today at 732-341-3800 to schedule a consultation.